Underlying this rather intricate combination of rules are 5 general themes or objectives. Sometimes these themes reinforce one another, but sometimes they are in tension. When considering how, if at all, the system of remedies should be modified, it's helpful to bring these objectives to the surface. When they conflict, it's necessary to decide which is the more important. The first, and least surprising, purpose is to compensate copyright owners, in other words, to indemnify them against loss. A copyright owner who has been injured by a defendant's infringement should be able to recoup from the defendant all of her losses. All 4 of the general theories of copyright law we have considered in this lecture series provide support for this first objective. Viewed through the lens of either fairness or personality theory, the rights that the law confers upon copyright owners are grounded in moral considerations: the moral right to a fair return for one's hard creative work, or the moral right to protection of the fragile bond between oneself and one's creations. Fidelity to those moral considerations requires, at a minimum, that copyright owners not suffer uncompensated injuries when their legal rights are abridged. Viewed through the lens of either welfare or cultural theory, the rights that the law accords authors and artists are designed to induce them to behave in ways that will advance some larger goal: generating and disseminating works that will advance net social welfare or will foster a rich and stimulating culture. Authors and artists will not be so induced if they are exposed to uncompensated abridgments of their rights. So, as to this first point, there's not much controversy. The second of the objectives is the prevention of unjust enrichment. We don't want infringers to profit from their wrongdoing, even if copyright owners do not suffer thereby. This is a very common sentiment, not just in copyright law, but in other fields as well. It looms large in contract law, for example. But despite its ubiquity, it's harder to justify and harder to connect convincingly to the general theories upon which copyright law rests. It seems connected to the same intuition that prompts us to recoil or object when a murderer writes a book recounting his crime and collects royalties from it. The third goal helps reinforce the somewhat shaky foundations of the second: deterrence. We want to craft remedies that discourage potential infringers from violating copyright owners' entitlements in the future. Litigation is enormously time-consuming and painful. A copyright owner forced to litigate can never be truly made whole. Thus, if possible, we want to deter people from infringing their rights in the first instance. One way to do so is to award and publicize monetary judgments that will make potential defendants think twice or thrice. The fourth ambition is punishment. Copyright infringement is wrong. We want to penalize the people who engage in it, not just to deter similar conduct in the future, but because the infringers deserve it. Another word for this is retribution. Finally, copyright law, as you know by now, aspires to create and maintain a delicate balance between, on one hand, the entitlements of creators, and on the other hand, the interests of the public in making use of their creations. The primary expression of the latter is the long list of statutory and judicial exceptions and limitations embedded in the copyright statute, the most famous of which in the United States is the fair use doctrine. Against this backdrop, we want to craft a set of remedies that will maintain that balance. In particular, just as we want to ensure that copyright owners have appropriate incentives to assert their rights, so we want to ensure that users have appropriate incentives to assert their privileges. In this respect, copyright infringement is fundamentally different from homicide, say, or rape. In those contexts, we're not particularly concerned about over-enforcement. If someone is not entirely sure what constitutes manslaughter or sexual assault, and his behavior is, to use the legal vernacular, chilled a bit, we're not troubled that such people are prompted to steer well clear of a vague line is not a serious problem. In copyright law, by contrast, chilling borderline behavior, in other words, discouraging people from engaging in activities that approach but do not cross the line of legality, is a serious problem. When setting and interpreting the rules governing damages awards, we want to avoid it. By now, the reason why these goals sometimes conflict should be clear. Goal number 3, and even more so, goal number 4, sometimes counsel larger awards than is optimal from the standpoint of goal number 5. The context in which these considerations are currently most salient is statutory damages. Most countries in the world do not currently permit copyright owners to recover statutory damages. A thorough analysis of the law of each nation in this regard can be found in a forthcoming article by Pam Samuelson, Tara Wheatland, and Phil Hill. Phil, as I think you know, is one of the teaching fellows in the edX course for which these lectures were in part prepared. The authors of that study demonstrate that only 24 of the 177 member states in the World Intellectual Property Organization currently allow recovery of statutory damages, and very few of the countries that do have such regimes also have copyright-based industries comparable in size and health to those in the United States. The U.S. is currently trying to change the state of affairs. Its diplomatic representatives are using various levers to try to induce other nations to adopt systems that resemble the system in force in the U.S. Why? Primarily because U.S.-based organizations representing at least some copyright owners have asked them to do so. Critics of this initiative make 3 arguments. First, many countries, unlike the United States, regard punishment of offenders as an inappropriate function of civil damage awards. Punishment, they believe, should be left to the criminal law, to which we'll return in the last segment of this lecture. The reason why this is relevant is that over time, the U.S. system of statutory damages has gradually taken on an ever more punitive role. Originally adopted primarily as a mechanism to provide compensation for copyright owners who have trouble proving the magnitude of the injuries they suffer, it now works in large part to penalize infringers. Many observers, especially outside the U.S., think that that's not a role for private lawsuits. Second, the critics point out that the broad ranges of permissible awards under the U.S. system and the paucity of meaningful guidance concerning how awards should be set within those ranges give judges and now juries too much discretion and result, consequently, in unpredictable, even arbitrary awards. Uncertainty of this sort is especially threatening to the delicate balance between private rights and the public interest. Third, and finally, some critics point out that the statutory damage system generates perverse results when applied in situations in which a defendant infringes a large number of works, each of which has only modest economic value. Because, as we have seen, copyright owners are permitted to recover statutory damages for each work, the result is to enable them to recover amounts that dwarf the injuries that the copyright owners actually suffer. The context in which this unanticipated problem has proven especially serious has been file sharing. The large majority of the individual defendants who have been sued by the record companies for unlawfully copying and redistributing sound recordings through file sharing networks have settled the claims for modest amounts of money. But the few defendants who have not settled have incurred enormous awards. Jamie Thomas-Rasset, for example, was found to have infringed the copyrights in 12 recordings, and after a series of 3 trials, ended up, as you can see, with a damage award of $222,000. Joel Tenenbaum was found to have willfully violated the copyrights in 30 recordings and ended up with a damage award of $675,000. In both of those cases, the trial judges balked at the magnitude of the jury's awards. In both instances, the judges concluded that the awards were so large as to violate the federal Constitution. In both instances, however, the Court of Appeals reversed, although the grounds on which the two courts of appeals did so differed. In the Thomas-Rasset case, the Eighth Circuit rejected the defendant's constitutional argument on the following ground. Applying the Williams standard, we conclude that an award of $9,250 per each of the 24 works is not so severe and oppressive as to be wholly disproportionate to the offense and obviously unreasonable. Congress, exercising its wide latitude of discretion, set a statutory damages range for willful copyright infringement of $750,000 to $150,000 per infringed work. The award here is toward the lower end of this broad range. As in Williams, the interest of the public, the numberless opportunities for committing the offense, and the need for securing uniform adherence to federal law support the constitutionality of the award. In the Tenenbaum case, the First Circuit concluded that the trial judge should have avoided the constitutional question. However, in so ruling, the First Circuit strongly intimated that, like the Eighth Circuit, it believed the Constitution had not been violated. In both of these cases, the United States Supreme Court declined to review the Court of Appeals decision. As a result, we do not yet have a conclusive answer concerning the constitutionality of such applications of the statutory damage regime. And we're not likely to get a conclusive declaration in the near future. The net result is that the struggle over statutory damages will continue in the political arena. Reformers in the United States will seek to curb them. Skeptics in other countries will likely continue to resist them or, more modestly, to discipline statutory damages with guidelines more precise than the vague standards used in the U.S. By contrast, representatives of copyright-based industries in the United States will continue to defend statutory damages and argue for the adoption of the U.S. model elsewhere. How this struggle will end remains to be seen.